Hi, I'm attorney Heather Poole. I'm speaking to you today about obtaining a green card or U.S. lawful permanent residence under the Violence Against Women Act. Always consult a competent licensed immigration attorney before filing for any relief, and if you are in this situation. Under the Violence Against Women Act, abused immigrants now have practical legal means of obtaining lawful immigration status or a green card without their abuser's consent and often without their knowledge. VAWA, what the Violence Against Women Act is abbreviated for short, has options available both to men and women immigrants. Green cards for married and recently divorced abuse survivors. Abused spouses or those immigrants who divorced their abuser in the past 2 years can still petition for an immigrant visa and file for a green card on their own if the survivor can show 1. That she has suffered extreme cruelty from her U.S. citizen or permanent resident spouse. 2. She entered into a valid, bona fide marriage with a U.S. citizen or permanent resident spouse. She entered into the marriage because of love or other reasons, not for immigration purposes. And 3. She has to show that she is a person of strong moral character, and no criminal background is the best way to show this. Abused spouses no longer have to show that they would suffer extreme hardship if forced to return to their home country. Even though this is no longer required, it is still applicable to a showing of extreme cruelty and can be helpful to making a strong case of abuse. The Vermont Service Center of USCIS accepts immigrant visa petitions for abused spouses. The showing of extreme cruelty, good moral character, and bona fide marriage can be difficult to prove due to evidentiary problems, especially if the immigrant has fled the abuser and is not taking any of the documentation with her. Proving intangible abuse, where it hasn't been documented by police records or medical records, can be difficult, but it's not impossible. Always talk to an immigration lawyer about alternate ways to prove your case. Unlawful presence. Abused spouses are exempt from the 3- and 10-year bars for unlawful presence in certain circumstances, although it is always wise to consult an immigration attorney before leaving for a trip abroad. You want to make sure that the consulate will understand that you have not triggered one of these bars. Deportation relief. VAWA also created waivers for criminal conduct and other bars to inadmissibility and grounds for deportation. It also extended motion to reopen relief for closed deportation hearings and final deportation orders, with certain exceptions if you are an abused immigrant. So even if you've already been deported, there may be options to reopen your case and reverse the order. A key part of VAWA is it can provide employment authorization, which is crucial to abused spouses who need to provide for themselves and often their children. Self-petitioning abused spouses with existing green card cases may petition for work authorization. Abused spouses married to permanent residents must wait for the approval of their VAWA self-petition, but then can apply for work authorization. Both abused spouses who are married to U.S. citizens and permanent residents, when they file for a VAWA claim, can receive deferred action status, which is a certain type of status that puts them on the very low priority list for deportation. In addition, one of the advantages of the new T and U visas, both allow the petitioner to seek employment authorization. So even if you do not have a permanent resident or U.S. citizen spouse, you still may be able to get work authorization through the U and T program. But perhaps the most favorable aspect of the Violence Against Women Act is that visas may be granted to those who have unlawfully been present in the United States, or those who have illegally crossed the border and have no papers to prove a lawful entry. Usually, for people who are married to U.S. citizens or adjusting in any other way, they have to show legal entry in order to get their green cards. This is an extremely important exception for abused spouses who do not have to show legal entry. It is extremely important to speak with an immigration attorney. If you are living in a controlling, abusive marriage with a U.S. citizen or permanent resident spouse, you may have options. There's other options available to you that are confidential and do not involve your spouse. Be careful though, and make sure you are calling the immigration attorney from a safe number or using a safe email, one that cannot be tracked by your spouse, so all communications do not put you at risk. It is often safer to call us or another immigration attorney from a payphone, from a library, public phone, using a calling card or from a friend's house, so your calls cannot be tracked. In my office, we also recommend that potential clients and existing clients who are abused spouses contact us through a new email that has nothing to do with their name or has any recognizable feature to preserve their confidentiality and to make sure as much as possible that their spouse cannot read their communications with a lawyer. There may be other immigration options available to you that are not discussed in this video. If you need my help, feel free to call me or fill out our consultation form on our website, humanrightsattorney.com. Thank you and good luck.